Okay, when I first started doing the videos and I done a little introduction um, to myself and who I am and how I got out of prison, one of the things I mentioned about me getting out through a decision in the federal court, and I just kind of wanted to share that with you. So here's the title of the case: was Hollister George petitioner versus uh, W.J. Sullivan, and as you can see down at the bottom, where I actually went in pro per, which means or pro se, I represented myself for the litigation. And then we got the opinion of the court, and it's talking about order declining to adopt the amended findings and recommendation, order granting petition for writ of habeas corpus. Now, one of the reasons that I'm actually proud of this particular or what I was able to accomplish in this, so where it talks about order declining to adopt the amended findings and recommendation. So in the federal courts, federal district court, the sitting judge will appoint a magistrate judge to hear all of the facts and evidence concerning the case. And at the end of everything, after all the litigation is done, they will give what they call a finding and recommendation. The findings will be all of the legal points and evidence that's been found in the case, and they will give their final recommendation. Usually, the district court judge will go along with whatever the magistrate says, right? Because again, the magistrate judge it isn't some intern sitting up in the position of a judge. It's an actual judge. They're just not the presiding judge over the case. And so they'll normally go along with the judge. So where it mentions order declining to adopt the amended findings recommendation, this is saying that I was able to object to the findings and recommendation because the magistrate judge was going against me, and I was able to win over the magistrate judge during my litigation. And this decision was made by Anthony W. Ishii. As you can see, federal court judge. Got a lot of respect for him for this situation because, as you'll see in part of the discussion, clearly he wasn't happy about it, and probably as a human being, if he had a decision based on his personal feelings about the situation, he probably would have never let me out of prison. However, he obeyed the law according to the way that the law was written at the time, and I was able to get out of prison because he followed the law as opposed to his personal feelings. So anyway, it starts off, says petitioner Hollister George, and they put George in parentheses because from here on out, it will refer to me as George, is a state prisoner proceeding pro se with a petition for writ of habeas corpus pursuant to Title 28 United States Code, Section 2254. George challenges the February 2007 denial of a parole date by the California Board of Parole Hearings, BPH. The magistrate judge issued a findings and recommendation on January 27, 2010, that recommended the petition be denied with prejudice. Now, where it mentions being denied with prejudice, so you can be denied with prejudice or without prejudice. If you're denied without prejudice, meaning you can get your evidence together, come back into court and relitigate the case. But if you're denied with prejudice, then you're pretty much done. So the findings and recommendation of the magistrate judge was that not only did I be denied, but that I be denied with prejudice, meaning I would not be able to bring the case back up again. And that the clerk be directed to enter judgment. The final recommendation was served on all parties and contained a notice that any objections were to be filed within 30 days of the date of service of the order. Now, any decision or anything that's made in the court, like the attorney general, when they're put their points against you or whatever, you always have an opportunity to issue objections to those. And this is no different, where the magistrate judge gave his findings and recommendation and I had an opportunity to object to what he was saying. On February 17, 2010, petitioner, that's me, filed objections to the findings and recommendation in accordance with the provisions of Title 28 United States Code Section 636B1C. This court has conducted a de novo review of the case, having carefully reviewed the entire file and having considered the objections. The court respectfully declines to adopt the magistrate judge's findings and recommendation and will instead grant George's petition. So again, I declined to accept the magistrate judge's finding and recommendation. And to me, this is huge, right? To the average person. And if you don't really like understand how the system work and the laws and stuff like that, and how the court decisions work, it's like, whatever, right? It kind of went with you. But to me, it was a kind of a big deal coming from a, uneducated, convicted criminal litigating his own case. I was actually pretty proud of that. So now it's going to go on and it's going to talk about some of the facts of the case itself. On November 28, 1989, Officer Garcia approached George and three friends in an area known for drug sales. So here it mentions, me and three friends. However, the rest of it, it's only going to talk about two individuals, myself and Tommy, or which they refer to as Mr. Armendariz, in this case, because the other two individuals fled the scene at the time, and they never knew who they were. Like it was never brought up who they were. I mean, obviously, I wasn't going to say anything, and they had no idea who the people were. Garcia observed a sawed-off shotgun in the vehicle and called for backup. George's friend Armendariz assaulted Garcia, which caused both men to roll down the embankment. Now, this, according to this, and the way that the facts were written during the case, it's saying that Officer Garcia observed a sawed-off shotgun in the car. I don't know if I actually believe that, because generally, if an officer shows up on the scene and he observes a weapon in the car, he's going to also draw his weapon, right? He never actually pulled his weapon until him and Tommy got into a fight. And even then, when he got socked by Tommy, he did not initially go for it. They were actually fighting, and Tommy went for his weapon. George's friend Armendariz assaulted Garcia, which caused both men to roll down an embankment. Garcia was wrestling with Armendariz, and Armendariz was trying to get hold of Garcia's service revolver. The two continued to wrestle together as Garcia tried to prevent Armendariz from removing his gun. Armendariz yelled at George, "Shoot the pig." Garcia then observed George holding the shotgun and pointing the weapon at him. So as they were fighting, I went back to the car, which there was, the sawed-off shotgun was in the car, and I went to the car and I got the gun. Now, at the time, and the way that everything was happening, they were in close combat. And the gun that we happened to have that particular day was a sawed-off 12-gauge shotgun. And obviously, anybody that know anything about shotguns, I would not have been able to shoot the officer without also shooting Tommy. Pointing the weapon at him, Armendariz continued yelling at George to shoot and continued to struggle with Garcia for control of the revolver. Garcia looked back up the hill and observed George shooting. Garcia saw a flash and heard the discharge of the weapon. When Garcia realized he was not struck, he bit Armendariz's arm, which caused Armendariz to release his grip on Garcia's revolver. Garcia then obtained control of the revolver and shot and killed Armendariz. Backup officers arrived at the scene and arrested George for attempted murder. While at the police station, George provided a blood sample that later tested positive for PCP and methamphetamine. George was 17 years old at the time of the incident. A jury convicted George of second-degree murder, possession of a sawed-off shotgun, and attempted murder. Objections, or see objections. Exhibit B. George was sentenced to a term of 15 to life plus 2 additional years for possession of the shotgun, for a total sentence of 17 years to life. Now, what's actually not mentioned here, so I was originally convicted of second-degree murder, possession of a sawed-off shotgun, and attempted murder, right? Which is, you can see right there. And I was originally sentenced to 24 to life. I was given 15 to life for the second-degree murder, which was the police officer killing Tommy, 2 years for the sawed-off shotgun, and 7 years for the attempt on the police officer. I think they actually done it as like a second-degree attempt or something like that. But during an appeal, I actually got the attempt dropped, and I think it was something about the jury instructions or something like that was the reason that it was dropped. So here it doesn't actually mention that. It mentions going back to the 17 to life, which later I ended up getting the sawed-off shotgun ran concurrent with the second-degree murder, which left me with 15 to life instead of 17 to life. George was committed to custody in 1991. See the objections, Exhibit A-B. In August 1994, the Court of Appeals stayed the additional 2-year sentence as a violation of Penal Code 654, but did not remand the case. George's sentence is thus 15 to life for second-degree murder. Okay, and the reason why he's in this part where he's pointing out these things about what the sentence is, because part of the findings and recommendation of the magistrate judge was, one, that I was sentenced to 17 to life and that I had not met my minimum eligibility date when the parole board denied me. So 2 things was wrong with that. 1, I was at that time sentenced to 15 to life, and 2, I was well past my minimum eligibility date. He had miscalculated based on other information in the record. And some of the record was kind of screwed up, which we'll see. The last reasoned opinion by any California court was the Riverside Superior Court. That decision reads, the offense involved great violence and an extremely serious attack with a firearm upon a police officer by the inmate. Petitioner's cohort was killed by the police officer after he was fired upon by the inmate. Sufficient evidence supports the board's action. Answer, Exhibit 2. So at any time that we file a appeal of the board hearing and we're going to take it through court, even if we're going to get up to the federal court, you have to go through all of the state courts first. And so I had to take it through the Riverside, which was the county of commitment, and then the 4th District Appellate Court, and then on to the California Supreme Court, and then into the Federal District Court. When a petitioner is in prison from state court adjudication and files a federal habeas corpus after April 24th, 1996, EDPA, and this EDPA, this is Anti-Terrorism Effective Death Penalty Act, that little acronym right there, governs, and a court will not issue a writ of habeas corpus unless it is shown that the state court decision denying relief was contrary to or involved an unreasonable application of clearly established federal law. So this was the standard. So to get into federal court, you had to have what they call a federal liberty interest to get into the federal courts with any thing that you were bringing up or saying that the state violated your rights. And so it's laying down the law and why I had a right to bring this case at the time. Now, I should say, though, that this right, or the federal liberty interest, was actually overturned later, subsequent to me getting out. I was really blessed because that case was going on at the time. And had that case came out when I was still in, I would have never got out. And matter of fact, that case invalidated the case that we're talking about here, And this case that I litigated myself, it actually became a published case in the federal supplements. I'm going to skip ahead a little bit. It says the findings and recommendations stated that the Ninth Circuit has held that a petitioner's commitment offense may be solely relied upon as a basis for denying parole when a petitioner has yet to serve the minimum term required by the sentence. The findings recommendation states that George was sentenced to 17 years, was committed to prison on September 3rd, 1993, and that he will not reach 17 years until 2010. The final recommendation concludes that because George was denied parole in 2007, he had not reached his minimum sentence and it was appropriate to rely on the commitment offense. So here the magistrate judge was actually in error. One, as already mentioned, I was sentenced to 15 to life, not 17, but also where it says that I was committed to prison in September 3rd, 1993 is incorrect. Now, to his defense, the record was kind of screwed up. I don't know how it happened, but somehow they did not include the issues or my YA stuff, right? So I went to start off in juvenile hall and got kicked out of juvenile hall, went to the county jail. And from the county jail, I ended up going to California Youth Authority. First, I did a 90-day observation. Then I went back and I was sent to Youth Authority with an M number. So when you go to YA, California Youth Authority, you can have an M number or a YA number. The YA number was like you were committed to YA. The M number, you were technically a state prisoner, right? Being housed in YA. And generally when you turn 25, they would just go ahead and send you over to prison. But I actually got kicked out before I turned 25. So this 1993 date that it has here, this is after I had got kicked out of YA, when in reality, I started serving a sentence in 91, technically at the end of 1990. So the magistrate judge went off the 1993 date, which was the date that I arrived at in prison. I was in Chad at the time, which is located up in Stockton. And I got kicked out of Chad for assault on staff. And when I got kicked out of Chad, they sent me to, well, actually, technically, before I got sent to prison. So they put me in a hole. And while I was waiting in the hole for them to transfer me over to prison, I went back on appeal. And that's when I, got, matter of fact, that was when the attempted murder when I first got the attempted murder removed, and they still had the 17 to life at the time. And it was later when I got the extra 2 years pulled off. So I come back to Chad. They end up sending me back to YA, back up to Chad. And I get back, they put me on in the compound. I was on American Hall, for anybody that's ever been to Chad. I was on American Hall. And so when they sent me back and they realized who I was, they was like, hold on, you already got kicked out. So they sent me back to the hole and then transferred me out to Tracy. I went to Tracy to do my reception, and I was trying to get down to Calipat because my family lives out in Riverside. And they end up sending me up to Pelican Bay in 1993. So this is where they're talking about this September 3rd, 1993. This was when I hit Tracy in the prison. So, but it wasn't when I started my sentence. I started it a couple of years before that. George objects and contends that he began his incarceration in 1991. After reviewing the record, the court agrees with George that he started serving his sentence in 1991. The crime and George's arrest occurred November 28, 1989. A 2002 psychological report states that George was received in the California Youth Authority, January 28, 1991, following a jury trial and conviction for second-degree murder. So, so this, fortunately, I still had, and I would use like all of my old psychological reports as part of the exhibits to show the time frames, because the record was screwed up. And once I was transferred over to prison, again, they didn't have any of my youth authority stuff, so they were not aware of those years prior to that, right? And I'm kind of glad that the youth authority stuff got lost, and I don't know how in the hell they screwed that record up like that, but I'm glad it did, because that would have caused me problems if they had known all of my youth authority activities. Because with the prison stuff, it appeared that I had a relatively good record. Okay, says appeal the sorry about that. Okay. The appeal opinion states that George was committed to state custody, but housed in California Youth Authority. And again, that's what I mentioned. I had an M number. I was M7593. And I had also had a state prison number. I was an E number, but at the same time that I had the M number for YA. The February 15, 2007 board hearing transcript states that the hearing occurred at Chuckawalla Valley State Prison. Chuckawalla Valley State Prison, and that George was received from Riverside County on March 21st, 1991 for second-degree murder. The transcript at 2, 3 through 7, finally, a legal status summary reads that George's life term starts at 3/21/1991, and that he was sentenced on January 28, 1991. See the objections, Exhibit A. The record is somewhat confusing in that the 2007 life prisoner evaluation, which the findings and recommendation relied upon, and the 2002 psychological report both indicate that George was received by CDC on September 3rd, 1993. So again, they have this because I was received by CDC on September 3rd, 1993. But what they're not realizing is that CDC and the California Youth Authority are not the same thing. And again, somehow they did not, for whatever reason, they didn't tie it in, even though it's mentioned above where it talks about me going into California Youth Authority. But anyway, however, in light of the hearing transcript, the date of imposition of the sentence, the Court of Appeals opinion, and the legal status summary, the court finds that George began serving his 15-year sentence in 1991. And so all of these things that it used for these evidence, these are things that I presented as, as exhibits. Because George began serving his sentence in 1991, 16 years had elapsed by the time of his February 17, 2007 hearing date. George thus had eclipsed his minimum term when he appeared before the BPH. The final recommendation is based on the premise that George had not yet completed his minimum term. The court therefore cannot adopt the final's recommendation. So now even all of this argument right here that they're talking about, the 16-year, the 17-year, all of that's wrong anyway, right? Because at the time I had to do 2/3 of the sentence, whatever the year amount was, according to the way the law was at that time. So I was eligible after 10 years, right? But because I was already past that 15-year mark, I just went ahead and argued it on the lines that they were already on, instead of trying to create a whole new situation. Because either way, I knew I could win, even if I was arguing, saying that, okay, I passed the 15-year mark. So I just kept it like that. Additionally, although the BPH may rely on the circumstances of the offense in order to deny parole date, such a decision will be upheld only if there is something about the facts of the crime that continue to show that the prisoner is currently an unreasonable risk. So anyway, this kind of goes more into the legal arguments and stuff like that. Um, and then down at the bottom again, it talks about uh, the fact that the finding recommendation um, said that I would continue to be an unreasonable risk to the public, and that's what the board's decision has to be based on. They had to show how I would be a current threat to the public if I was released, and the findings recommendation was saying the same thing. However, I argued that there was no evidence to prove it or um, to back that up. So anyway, um, this is just some more stuff related to the case. It goes down to the factors and it talks about the judge's arguments and stuff like that. And so I include these pages again. And all this stuff actually can be found online. The actual whole case can be looked up and found online. So I actually started to represent myself when not only on, filing the writs, I began to represent myself going to the parole board because they would assign you an attorney to represent you at the parole board. But what I started to see is that the attorneys, to me, for the most part, the ones that were assigned to you, sometimes it appeared that they were more on the side of the parole board than the inmate. Also, even those that were on your side, they had their own ways of doing things. And of course, they're attorneys and they know the law. But I had got to the point where I was frustrated with the parole board. I was clearly not going to get a parole date because half of the parole board at the time were former law enforcement, and I had an attempt on a police officer. So I started going to hearings to set the record so that I could file a writ later in court. So, because anything that you filed a writ on and when you appealed the board hearing, it had to be directly associated with the transcript. Your transcript was your evidence that you're going to have to use. So I wanted to set the record. And so I noticed that when I would go in and I would tell the attorney how to approach the board, what questions to ask them, what questions to ask me so I could respond in a certain way, they wouldn't want to do it. And they would talk about how they didn't want to piss off the parole board. And my thing was, I'm like, man, fuck the parole board. I'm the one that's pissed off. I'm the one that's sitting here, serving my life in prison. So I don't give a shit if they get pissed off. I want to set the record so I can file my writ later. They wouldn't do it. So I actually fired the attorneys. And whenever they would try to assign me an attorney, I would not take attorneys with me. And I would go to the parole board and I would represent myself and I would set the record. And that's actually how I won this writ. I set the record so that I would be able to file the writ on specific points, right? Because I knew the board would always use the same inflammatory language every time you would go in. They would use almost the same reasons for denial and boilerplate language such as you need further therapy to help and cope with stress in a non-destructive manner and all these type of things. So I would ask them questions. And in the last hearing, or this wasn't the last hearing, I actually had a couple hearings after this hearing, but this was going on in court. And I actually started litigating. Every time I would go to the parole board, I would file another writ. And I had to have like 7 or 8 different writs floating around at different levels throughout in the courts, as well as I used to represent other people, people, out there on Facebook and stuff like that, that were former lifers that I helped them litigate their case and get out of prison. I even had one individual, I litigated his case, helped him get out, but he didn't even have the courtesy to even say anything. I found out through another inmate that he got out when I went to the yard, kind of checking on him to try to see what was going on with his case. And they're like, yeah, he's gone already. So I'm like, oh, they're like, yeah, you won, he hit on that case you filed for him. He ain't tell you? I'm like, nah, I ain't say nothing. Like, whatever, I'm glad he won because, again, my thing at the time, I felt that no matter who was winning, it was just one more win for the people, um, and so that was my thing. So anyway, I stopped taking the attorneys. I started representing myself at the parole hearings, and to set the record, I went to, I believe, a total of 8 hearings. This was actually my 5th hearing, the hearing that's talking about here. It was my last hearing while I was at Chuckawalla. I think I went to my first hearing when I was at Ironwood. I didn't have any hearings while I was up at Pelican Bay. Yeah, Ironwood, I went to my initial hearing, and then I had a few hearings while I was at Chuckawalla. Then this was my last hearing at Chuckawalla because they ended up turning it to a SNY yard. And then I went to Tehachapi, which turned to SNY yard. I think I had one hearing at Tehachapi as well, but they turned that to SNY yard. Then they sent me to SATF, or New Corcoran, and that's where I paroled. That's where I paroled from, and that's why it talks about also. Matter of fact, I believe when I filed this particular writ, I was still in um, uh, Tehachapi at the time, right? Um, I was still in Tehachapi and filed the writ from the hearing that I had at Chuckawalla. So anyway, that turned out excellent. So then, so this ordered the board to ended up ordering the board to set a parole date. Find me suitable. Set a parole date, and then I ended up filing another petition was actually filed that order for the release, right? Because when you go up to the parole board and the parole board give you a decision, the governor has a right to take your parole date away. Also, the parole board can try to extend it like far out there. So then another order ended up coming, ordering them to actually release me, and I actually have that as well. So anyway, that was how I got out of prison.